S4's webinar series and joining today's webinar. I am Tanu Prabhakar, working as Deputy Manager HR Advisory of Sanam S4 and supporting new foreign companies in India with their local HR requirements. In continuation with Sanam S4's webinar series on HR-related topics, today's webinar is about newly introduced Sexual Harassment of Women at Workplace Act 2013. I have my colleague Rohan with me today, who would be leading this webinar while I will serve as a moderator. Rohan Muktali is the head of HR advisory practice at Sanam S4 Consulting and function as a key HR advisors for various newly arrived foreign players in India. Through today's webinar, we aim to create awareness about this act in discussion with our listeners and would be happy to take questions at the end of the webinar. This webinar will have following steps. Rohan will talk about the features of the Act in detail. Audience will be asked poll questions in between and they will be provided with the answers once the duration of the question gets over. And once we are completed with the webinar, we will have the Q&A session at the end of the program. I hope you will find this webinar quite relevant and useful to your interests, and I will appreciate your time given to us. So Rohan, over to you.
Thank you, Tanu. Good morning and good afternoon, everyone, based on the geographies you are in. As Tanu introduced me, my name is Rohan Muktali and I head the HR advisory practice of Sanam S4 Consulting. For those of you who are not aware, Sanam S4 is a single window market entry service provider organization. We facilitate entry of many foreign businesses in India and offer end-to-end solutions and holistic services which are needed for a new organization in India. We've been in the market for over 7.5 years now, and we very proudly host more than 150 clients as an organization. Under the HR advisory practice of Sanam S4, what we do is we offer advice on the best practices of HR and on the complexities of Indian employment law to the new foreign companies who are entering in the Indian business market. One of the things which we regularly do for our clients is we keep them updated on the changing horizons within the framework of employment law in the country. So one of the newest laws which have been introduced by the government of India is the Sexual Harassment of Women at Workplace Act, which obviously over the next half an hour to 45 minutes we will cover in detail, and that actually happens to be the subject of today's discussion. I would certainly want this webinar to be an interactive one, so I would request each one of you who can actually listen to me and hear me right now to ask as many questions as you can, and we will be very happy to respond to your questions. So let me quickly take you through the format of today's webinar. So what we aim to cover today is the whole objective of conducting this webinar, to set up some general expectations and also to let you know what are the general expectations of people when they attend a program like this. The background to the whole act today become a key for every organization. Then the whole scope in detail, giving the references of the various legislations, the responsibility of your employer, and the whole process around complaint investigation and address or the review process. And we will also then quickly touch upon some of the provisions against anti-sexual harassment in different countries. So I would like to start the webinar now, and we will have an audience poll periodically. So Tanu would take us through the audience poll today, and then based on the questions you will be asked to offer your opinion. So I would request you to actively participate there as well. So as an objective, what we really aim today is we want to offer key insights pertaining to the Sexual Harassment of Women at Workplace Act 2013. The idea is to also create awareness of the topic within newly set up companies in India who employ 10 or more employees, because that's the key requirement wherein the ambit of the act comes in the picture. and also ensure that companies and HR professionals who are listening us today have a solid understanding of the implications of the various provisions in the Act and related matters from varied perspectives, which also include cultural, geographical, and legal perspectives. So we really hope to really create that awareness today and hope to achieve what I just listed in terms of the content. Whenever we do these webinars, or we also do seminars in offices where companies invite us to orient their employees on this act. So, what expectations employees typically have is they also uh, have some specific expectations here. So, they want to know what really this act is all about. So, the clarity on the subject is important. The content, what this act is all about and how it's applicable to the organization. The confidentiality part, that whether these things are discussed in open or they are kept confidential. The fair judgment process, the sensitivity around the topic, and then some of the feedback. So we will also today keep our discussion limited to these things, and as they largely carry most of the expectations. um, Now, let us start with understanding why the government of India felt the acute necessity of enacting an act like this. So, if we actually look at the Constitution of India, which is obviously quite comprehensive, and it offers various sections, but there are certain articles which, if I may quote, if we look at Article 14 and Article 15, uh, the government of India said under those articles that sexual harassment is a violation of the fundamental right of a woman to equality. So Articles 14 and 15 actually guarantee the equality right to women in India. So an act of sexual harassment is directly seen as a violation to the Articles 14 and 15 of the Constitution of India. Article 21 in the same Constitution also offers the right to a woman to live her life with dignity and with respect, and she also has the right to live her life uh, with utmost dignity even at workplace. So that's Article 21. And further down, if we actually look at Article 19, Section 1, it it says that a woman has a right to practice or to carry out any occupation, trade, or business with her right to dignity, and that too in a safe environment which is free from harassment. So if we combine all the articles, which is Article 14 and 15, which is basic guarantee of equality, Article 21, which is to live her life with dignity and respect, and Article 19(1), which guarantees a woman to conduct or carry out any business, trade, or occupation in an environment which is free of any harassment. So all of this put together confirms that a woman is entitled to a harassment-free workplace. Obviously, some of these, elements in the society have been perpetually violating these rights, and time and again, these issues have been put forth in front of various forums, and the debates or the discussions have always led to a point that India is still a bit more tolerant, if I may use the word, given today's scenario, towards these kind of harassment, and there is no strong law which is uniform, which covers different places of occupation, and also which is uniform across the country. So there's a deviation to this. So what happened is in about 1997, uh, there was an ongoing case between a woman and the state of Rajasthan, which was the rule or the diktat was given in the favor of the woman, and from that day onwards, from the day the result was or the judgment was given by the honorable court, from that day, the government entities and the PSUs incorporated in their policy something called Vishaka guidelines. The Vishaka guidelines is nothing but it's just a clear-cut policy which offers clear guidelines on the various uh, provisions of anti-sexual harassment within the government setup, They want to ensure that the employees of Government of India, state government, and PSUs are working in a harassment-free environment. And Vishaka guidelines then also offers the guidance on setting up a committee and the different requirements of the committee and how the committee will play a crucial role in addressing a sexual harassment case if it comes in front of them. So finally, in 2013, India enacted its law on prevention of sexual harassment against female employees at workplace. So the female employees at workplace should get guarantee of harassment-free work is the basic objective of this act. And in December 2013, on 9th of December 2013, the act actually came out. In April 2013, on 23rd April 2013, by way of publication in the Gazette of India, the act was introduced. But in the month of December, on 9th of December 2013, the act was enforced on all the companies in India who employ more than 10 employees. And the act was called Sexual Harassment of Women at the Workplace, bracket Prevention, Prohibition and Redressal Act 2013. So I think let's take a quick poll question at this moment, and then we will go to the next section and understand the act in detail and the scope, etc. So may I request Tanu to host the poll question, please?
Sure, Rohan. So we will have the poll questions appearing on the attending screen right now. So the first poll question of the day is, what should be the headcount of the company to come under the ambit of the provision of the Sexual Harassment of Women at Workplace Act 2013? Your options are A 20, B 15, C 10, and D no specific headcount required. So the audience is given time right now, so the duration starts right now to respond. Okay, thank you so much for your participation. So let's see what is the result of this poll question. Okay, so the answer for this is, so we have the survey of the poll question where 33% of our audience have responded for option number C, which is 10, and 16% has responded to option number D, which is no specific account required. So the correct answer for this poll is C, which is 10. So the minimum requirement is 10 employees for any organization to come under ambit of this act. So Rohan, would you like to throw some light on this?
Absolutely. Thank you, Zanu. And thanks to all of you who participated. Yes, so 10 is the number which decided by the government while introducing the act. So any organization in India who directly or indirectly employs 10 or more employees falls under the ambit of the act. So as we proceed with the presentation, we will be talking about what are the requirements of the Act in terms of having a committee and to who all this Act is extended. But the answer is right, it's 10 employees. So we go back to the presentation again, and we now talk about, we just discussed about what was the background and why the Act was introduced and what basis does it form in terms of having a statute around this matter. So, as it is written in the Act, I would read it verbatim, that what is sexual harassment of women at workplace? How is it defined? So, primarily, this is an act to provide protection against sexual harassment of women at workplace and for the prevention and redressal of complaints of sexual harassment and for matters connected therewith or incidents thereto. It extends to the whole of India. So the Act provides a quick guideline, or it lists few behaviors which actually construe to be sexual harassment. So the law as it has listed, it says that sexual harassment includes any one or more of the following unwelcome acts or behaviors, whether directly or by implication, namely physical contact and advances, or a demand or request for sexual favors, or making sexually colored remarks, or showing pornography at workplace, or any other unwelcome physical, verbal, or non-verbal conduct of sexual natures. Now, as you see that there are some explicit examples here which are quite understood, but then there's also some gray area. If I look at the last point, which is point number 5, it says any other unwelcome physical, verbal, or non-verbal conduct of sexual natures. Now, given this gray area and the ambiguity, it's all the more important for everyone to know what is this act all about and what are the different behaviors which are considered to be potential acts of sexual harassment. And therefore, one of the things which we do is we talk through the webinar and create that awareness. So let's understand what is the scope of the law. What is really important, and to how and where is it applicable. So the act is very wide, and it's applicable to the organized sector as well as the unorganized sector. So there are certain sectors in India which are still unorganized, namely could be construction, the real estate, but the act doesn't really limit itself to the organized sectors, but also has been extended to the unorganized sector of India. So the act is applicable to all government bodies, public and private sector organizations, NGOs or non-governmental organizations. All those organizations, those carry commercial, vocational, entertainment, education, industrial, financial activities, including hospitals, nursing homes, education institutes, sports institutes, and stadiums, which are used for training individuals. The workplace also covers within its scope the places by which are visited by the employees by virtue of their employment, or for the reasons which are arising out of their employment, which also include transportation provided by the employer for the purpose of commuting to the workplace and coming back home from the workplace. Which means that the government has really endeavored or has really made sure that no particular sector, whether organized or unorganized, or any uh, institution or body, has excluded itself from the purview of the Act. The intent is to extend the Act to as many sectors and organizations and private bodies as possible, so that if there's any act which takes place related to today's topic in any of these institutes, then it can be addressed well. The Act further also defines who is an employee under the Sexual Harassment Act. It's very important for everybody to know. And when the Act was formulated, it was an imperative to make sure that the definition of an employee is clear and explicit. This is because if a case is before the committee, the wrongdoer cannot escape by saying that he or she or the person who's the victim of the act was not an employee of the company and therefore the act is not applicable, and perhaps then the issue can be sorted out of the office or on a mutual settlement basis. So the law says that the act is applicable to any woman who falls under the definition of employee under the Sexual Harassment Act, and it encompasses all the regular permanent employees, temporary employees, ad hoc employees, individuals engaged on daily wage basis, either directly or through any agent, contract labor, trainees, apprentices, with or without the knowledge of the employer, which means that even the contract staff working or the contractors who deploy people working in your organization, temp staffs, interns, apprentices, everyone is covered under the ambit of the act. So that's the way it's the act is made as comprehensive as possible, and the extension is to almost every employee who's associated with the company. I think it's time again now to take another poll question. So over to Tanu for the next poll question, and then we'll take it from there.
Thanks, Rohan. So we will have the second poll question appearing on the attendee screen right now. So the question is here, are NGOs covered under the scope of Act? Your options are A, yes, and B, no. So your time starts now for answering the question. Okay, so thanks so much for your participation. Let's see what are the results now. So here we have the results of the poll question, where 50% of our attendees have stated yes, and no one has responded for option B, which is no. So Rohan, would you like to share your views on the same?
Sure, Tanu. Excellent. So that's the right answer. You know that NGOs or non-government organizations, or NPOs, we call them as the non-profit organizations, they are also covered under the scope of the Act. This is because today, if you look at the way employees are, people are employed in NGOs and NPOs, most of the statutory acts like the Shops and Establishment Act are applicable. So there's a definition or a requirement of offering minimum amount of paid leave for them, holidays, etc. So the government again did not want to exclude NPOs and NGOs just for the fact that they perform business without profit, but then still obviously there will be a high amount of staff working for those organizations, and obviously women employees would be a part of that. So it's also to encourage women to join more and more NGOs and NPOs who obviously deliver the cause for the noble cause for the society. So while the women are encouraged to join those organizations, obviously there's a guarantee that the intent of that organization is to provide an environment which is totally anti-sexual harassment oriented, and obviously to provide a harassment-free atmosphere to the women at workplace. So let's move again to the contents and of the presentation today. Uh, so now we'll talk about what is the responsibility of the employer in concerns of sexual harassment, or under the ambit of the Sexual Harassment Act or the Anti-Sexual Harassment Act, if I say so. What is an employer supposed to do? We understood just now that who is defined as an employee and who are the people who are considered as employees under the ambit of the Act. So now we'll understand what is an employer supposed to do uh, and in regards to the provisions of the Act. So the first and foremost thing which is important for an employer to do to actually create a deterrent or to prevent the commission of act. Obviously, the act provides a process and a whole mechanism to address the act, and conduct an inquiry, and then if the alleged wrongdoer has done something wrong, then to penalize the person. But before that, it's important that a deterrent is there, or there is an effort put in by the employer to actually prevent these acts from happening. If the employees are aware that the employer is extremely sensitive towards this subject, and there's a high amount of intolerance towards any harassment in the organization, obviously the likelihood of commitment, or conducting these acts, or the possibilities of occurring of or occurrence of such acts is going to be very less. So, and the next responsibility of the employer is to provide the procedures for the resolution, settlement, or prosecution of acts of sexual harassment by taking all necessary steps required. Uh, the employer also is responsible for an express prohibition of sexual harassment at the workplace, and that if there's any such act, then it is notified, published, and circulated in appropriate ways, which means that clarity is offered to employees, orientation programs are held at regular intervals, and enough awareness is created within the teams about the acts and all the provisions of the act. So everyone is an informed employee, and people have optimum clarity on what is this act about, what is the role they play there, and how important it is for all of us as we do our day-to-day jobs to be sensitive and extremely sensible towards the provisions of the Anti-Sexual Harassment Act. The employer also is supposed to set up an internal complaints committee, or ICC as it is called as, under the mandate of the Act, where the ICC, which is the acronym for Internal Complaints Committee, is supposed to consist the following members to be nominated by the employer. So the duty of the employer is to make sure that the ICC is formed. So the formulation of the Internal Complaints Committee is one of the key requirements of this particular act. So the employer has to ensure that the presiding officer or the person who would lead the committee is a woman, and she's employed at a senior level, and she's also amongst the employees. It will be useful, obviously, if the woman who is appointed as the presiding officer or the chairperson has relevant experience or has worked for the cause which deals with matters which are in discussion today. While creating the committee, the employer also has to ensure that not less than two members from amongst the employees, preferably committed to the cause of women or who have experience in social work or have legal knowledge about this, have to be a part of the team. One member also has to be amongst the NGOs or somebody who is again worked for the cause of women or who is familiar with the issues related to sexual harassment, and ultimately that at least 50% of the total employees who sit on the committee, or the 50% of the members at least, should be women. Um, so if there's an organization which is relatively small and has a committee of, let's say, three members, then the presiding person or the presiding officer would be a woman, of course. But then out of the two members, one has to be a woman. So if there's a committee of five members, in addition to the presiding officer, who is the chairperson, the rest of the two people, or out of the four people, rest of the two should be women. Then the act also further clarifies that the employer is supposed to organize workshops, as I said some time ago, and create create employee awareness programs at regular intervals for sensitizing the employees with the provision of the act, and then also regular programs have to be conducted for educating the committee, and the discussion should be held if cases are coming at regular intervals. And obviously, ultimately, where sexual harassment is apparently occurring or seen to be, happened, or if it occurs, then as a result of an act or omission by any third party or outsider, then the employer and the person in charge will take all steps necessary and reasonable to assist the affected person in terms of support and preventive action, which obviously are in line with the Act. Uh, Now we'll quickly touch upon the complaint investigation and review process in India for this particular act. That if at all a complaint is put forward or brought forward by an employee, then what is the employer supposed to do and how the whole mechanism works. So there are some conditions also for an employee who's given the complaint in writing. So an aggrieved employee or the employee who was subject to the act or the harassment should be giving the complaint in writing within 3 months from the date of the sexual harassment incident. Obviously, the same should be reported in writing to the Internal Complaints Committee, the ICC, and generally in line with the act, the expectation is that 6 copies are submitted uh, 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 with the complaint. Then in an event of the complaint of sexual harassment raised, the committee should also understand then the allegations and initiate an investigation. So whatever comes in front of the committee, then they should look at it and then understand the whole allegations and the matter, and then start the investigation. The committee is also expected to gather facts via meeting people, interviewing them, collecting data and documentation relevant to the case and the allegation. Typically, what are the steps are conducted are, there is an interview of the complainant or the victim, the identified witnesses, if at all they are available, and the alleged wrongdoer. So all these people are interviewed and in detail, and interrogation is conducted. And then finally, the committee would review the investigative process and findings, and understand if the findings are good enough for them to reach a conclusion, or if the findings are inadequate, then to make recommendations for further investigation or buy some time. And wherever they feel that the conclusion is apt, then make recommendations for disciplinary action if the alleged wrongdoer is found guilty of the whole process of the act. And then the committee should also update the documentation, notify the complainant of high level outcome, and close the case. So it's important for the committee to go back and tell the complainant about how the case has been resolved and what's the next step. So it's quite a detailed process, and cooperation is expected during the interrogation and interview process from the people who are involved, could be witnesses or the alleged wrongdoer, or from the complainant itself. Let's take a quick poll question at this moment, and then we will go on to the next slide. So, Tanu, over to you, please.
Thanks, Rohan. So let's take up the third poll question of the day today. Okay, so the poll question is, does this act offer guidance to the matter pertaining to sexual harassment of men at workplace? So your options are A, yes, B, no, C, partially. So the time starts now for responding to this question. All right, so here we have the result of the survey. Okay, so 33% of our attendees have answered for option number B, which is no, and none of our attendees have answered for option A and option C, which is yes and partially. So, Rohan, would you like to discuss this a bit in detail or share your views on the same?
Certainly, Tanu. Thank you so much. Thanks again for participating in the poll question. The question was that does this act offer any guidance to matters pertaining to sexual harassment of men at workplace? And the answer is no, which is quite right to all who have chosen no as an option. Because if you look at the title, the subject itself says Sexual Harassment of Women at the Workplace Act. So if you recall the background which I gave to all of you at the beginning of this webinar, is that all of this loops back to the various rights which are offered by the Constitution of India to a woman in India, whether it's her right to life, to live with dignity, or to conduct any trade, occupation, or business. So the act has been always revolving around the safety of women and offering a harassment-free environment to a woman at workplace. So the act was enacted with total focus on the safety of women at workplace and having anti-sexual harassment provisions, and obviously a complaint mechanism, most importantly, with the committee in place in the ambit of the act. So unfortunately, the Act does not offer any guidance, or there are no provisions which offer or throw any clarity on guidance or guidance to matters pertaining to sexual harassment of men at workplace. If any such case is reported or if any such matter occurs, then that is dealt best under the various prevailing policies of the company, which could be an HR or employee handbook, could be code of conduct, or any other provisions offered by the employer in terms of dignity at workplace, or any such policy which offers equality and dignity at work to all the employees. So let's go back to the content and the presentation, and now what we will discuss. We thus far we've discussed what the scope is all about, who all fall under the ambit of the act, and what is actually sexual harassment as per the law. Who are the employees who come under the ambit of the act? What are the different obligations of the employer? And then obviously we've also just understood what is the review process. So I would now request Tanu, my colleague, to talk about what are the various provisions which are listed under different countries. As I'm, this webinar is also meant for our, uh, uh, colleagues in different countries, and typically today we are focusing on Australian population. So if anybody from Australia is listening us today, can also understand how it works in different countries as against it in their hometown or their home country. So Tanu, over to you, please.
Thank you so much, Rohan, and thank you for covering up the act in detail with our audience from India perspective. So here we will, throw some light on the anti-sexual harassment provisions across various countries. So we'll see that how in different countries this anti-sexual harassment act differs. So we'll first take up United States. We will talk about the definition of this act in this country. So in United States, sexual harassment is any unwanted act or behavior with sexual undertones and negatively that impacts the recipient's work environment. Vis-a-vis in United Kingdom, this definition is basically the sexual harassment is unwanted conduct on the grounds of person's sex or unwanted conduct of sexual in nature, and that conduct has the purpose or effects of violating a person's dignity or of creating an intimidating, hostile, degrading, humiliating, or offensive environment for them. So this is about the definition of sexual harassment in United Kingdom. So we'll cover up the definition in Australia as well. Sexual harassment, it is unwanted or unwelcome sexual behavior which makes a person feel offended, humiliated, or intimidated. Sexual harassment is not an interaction, flirtation, or friendship which is mutual or consensual in nature. Sexual harassment is a type of sex discrimination, which is, as per Australian sexual harassment provision. In India, which we have already covered, but I will just reiterate the same that what is the definition of sexual harassment in India. Sexual harassment is any unwelcome sexually determined behavior, whether it is directly or by implication, such as physical contact or advances, demand or request for sexual favors, passing sexually colored remarks, showing pornography, or any other unwelcome physical, verbal, or non-verbal conduct which is sexual in nature. It constitutes under the definition of sexual harassment. So there are various laws in these different countries which are protecting the sexual harassment of women at workplace, which are basically anti-sexual harassment laws in these countries. So in United States, sexual harassment is covered under the ambit of Civil Rights Act, uh, and under the Civil Rights Acts, there are various anti-sexual harassment provisions for the employees. Then in United Kingdom, we have the Equality Act, in bracket sex discrimination 2010. So this act was applicable in 2010 with a lot of amendments that were done. Then in Australia, as I mentioned previously, that sexual harassment is basically a sex discrimination. So in Australia, we have Sex Discrimination Act 1984. And in India, which we are talking about, and this whole webinar is all about. So in India, we have the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013. So we also call it as Sexual Harassment Act. So this is the laws that are prevalent in these countries. Now we'll talk about the scope and applicability in various countries. So talking about United States, the act which we have talked about that covers the employers under the ambit of the act. So it covers all the sectors and it is applicable to all the employers employing more than 15 employees. So any employer that is employing more than 15 employees in United States is covered under the ambit of Civil Rights Act. Then in United Kingdom, it covers all the sectors irrespective to the number of employees. So any sector that is employing n number of employees has to abide by the law. Then in Australia, we have the same. It covers all the sectors and number of employees. And in India, which we have already covered, it covers all the private, public, organized, unorganized sector. And the act is only applicable if the employer is employing more than 10 employees. So this is about the scope and applicability of the act. I hope it offers clarity to our attendees about various provisions of anti-sexual harassment in different countries. So we will move on to our presentation, and now we are done with our session. We'll have the question and answer session. So our webinar is open for our audience to put forward questions to our speaker.
So till we get some questions, and I would just like to kind of summarize what we understood and what we discussed today. So largely, most of the countries, which are developed nations, whether it's United Kingdom, USA, Australia, and India, which is now, turning to be one of the, biggest economies of the world. is ensuring that adequate policies and provisions are put in place for anti-sexual harassment. So there's not material difference in the definitions which are provided for, around sexual harassment in each of the countries, and obviously there's a prevailing law. So the summary is that India is now no more tolerant in any such matter. Employers are expected to be absolutely sensitive about sexual harassment. Potentially, if it happens in the organization, they should be sensitive about having provisions in line with the act, and they're expected to be compliant. They have to make sure that a committee exists, and the formation of the committee again is as per the guidance provided by the act. Employees should be very regularly made aware about various provisions of the act, and the employees also should understand their own responsibilities. So it's important that everybody is now aware and on the same page when it comes to this particular act. We really hope that you found these insights helpful. So let's see if we have any question coming here.
Yes, so we have the first question from our attendees. Basically, these are three questions which our attendees have, one of our attendees has put forward. So the question is, what legal remedies do male employee who face sexual harassment have? And in continuation with this question, we have, is the consultant considered as an employee? And are the jokes about the spouses, which is generally to make fun or of nagging wives, considered as harassment? So, Rohan, would you like to discuss the same?
Sure. Thank you for posting this question. So let me answer and respond to these questions one by one. The first is, what legal remedies do male employees who face sexual harassment have? So as I explained some time back, that unfortunately this act, the sexual harassment of women at workplace, does not address any sexual harassment of male at workplace. So what if such an act happens, or if a male is subject to sexual harassment at workplace? So there are two ways it can be dealt with. As I said some time ago, that we need to refer to the policies of the organizations. Most of the progressive companies and large multinationals operating in India have a code of conduct which deals with dignity of an employee at workplace. So if a male is subject, or male employee is subject to sexual harassment, it means that his dignity at work is compromised. So under the code of conduct, an action can be taken. Most of the cases, it's a disciplinary action, which may also include termination based on the gravity of the harassment. At times, the companies who don't have a code of conduct do generally have an employee handbook or provisions, or a manual which explains the rules and service conditions of employment. So some of those provisions do address harassment as such, or equality or discrimination. So taking reference from those policies, or employee manual, handbook, and code of conduct, the remedies can be sought. If the organization does not have any of this, then the male employee has very much an option within his legal rights to seek advice of a legal counsel, who is an external counsel, and take the matter ahead. However, the expectation is obviously to first discuss this with the employer, and reach out to the HR team. And I'm saying this, which is an absence of any clear guidance in any of the employee rule books. So they can talk to the HR team, talk to the employer first, and they always then can approach an external legal counsel. The second question was about, is a consultant considered as employee? Yes, if you have a female employee, or a female consultant who's in the act of the law is seen as a contractor or an external contractor, definitely then falls under the ambit of the act. So to precisely respond to your question, yes, a consultant, for the purpose of this act, of the consultant who is a female consultant under the ambit of the act will be considered as an employee. And the third was that any jokes which are made or cracked about spouses, typically made about where fun of nagging wives is made can be seen as harassment. In my opinion, no, this cannot be termed as sexual harassment. This is more of a part of the humor created within organization. It depends on the relationship between the person who has cracked the joke and the person who is subject to the joke. Uh, if I see it from a policy perspective, it could be seen as an intrusion in somebody's private space, and again can be dealt effectively based on the case, and based on the policies which are applicable, where some again could be potentially a dignity of work issue, but definitely doesn't fall under the act, because harassment has been clearly defined, and which we spoke some time back about. There are different activities or acts or behaviors which fall, like physical advances or showing pornography or any unwelcome act, but then any such humor which is made or created on relatives of the employee, then could be best dealt under in the code of conduct of the company. I hope I've answered all the three questions. Tanu, over to you, please.
Thanks, Rohan. So we have another question from our attendees today. So the second question from our attendees is, does the internal complaints committee require to have a counselor? So Rohan, over
Sure.
to
So
you.
thank you. Sure, I'll respond to that. Thank you for asking this question. So the question here is for the benefit of others, that does the ICC or the Internal Complaints Committee require to have a counselor? There is no such legal provision in the Act to actually have a counselor, but what is important and what is expected under the ambit of the Act is the ICC is supposed to be aware of various provisions of the Sexual Harassment of Women at Workplace Act. They should be absolutely clear about their responsibilities as a committee member, and they should be aware about what the committee is expected to do when a case comes in front of them and how do they resolve. So they, if necessary, they may seek help of a counselor, or they may seek help of external HR consultants who are expert in such matters as we are, perhaps, and or they can then choose to empanel the fourth person or the external person, which is also a requirement in the Act, who's working for a cause of the women, or who works for an NGO, or who's a specialist under this Act. So that person could then act as a counselor. But as a mandate, there is no such requirement to have a counselor. The requirement only is to have an external person who's preferably working for an NGO which is working towards the cause of women, or who's got enough and adequate understanding, or who's a specialist in this matter. Hope that helps.
Thanks, Rohan. So we have another question from our audience today, which is, I'll just state, it is the field staff who were contracted for research work also come under the law. Do we need to make them aware about this act? If they don't give complaint in writing, how do we deal with it? So over to you.
Sure. Thank you, Tanu. Thanks so much for asking this question. Quite an interesting question. The first uh, question is that, I mean, rather, it's an assumption that the field staff who are contracted for research work also come under the law. Yes, you're absolutely right that irrespective of what the role of the employees, uh, the act is extended to the contractors. So if there's field staff who are contracted for research work, and if there are women in that team, definitely, the law is applicable to them. And yes, as one of the provisions of the law says, awareness is needed for them as well. So they should be involved, or they should be participants if any orientation program or awareness program is organized by the employer around this act. Now, the third question is, they don't give complaint in writing. How do we deal with it? So again, we go back to the provisions and the guidelines given very clearly by the law, that the complaint should be coming from the victim, the alleged casualty of this act, in writing, and that too in 6 copies. So anything which is spoken verbally may not be addressed as per the guidelines, or I would simply say that the act doesn't really kick in till the complaint comes in writing. if there's any verbal complaint made, then obviously it can be best resolved in an informal manner where the HR team and the person who's the complainant and the alleged wrongdoer can be brought into a room and things can be discussed in an informal manner. Nowhere it can be put on record. No documentation should be carried or conducted here, and legally it cannot be seen as a case of sexual harassment. Only if it comes in writing, then yes, it's got a formal legal weight, and then the committee can consider. Again, when it comes in writing, it has to be presented to the committee, and which means again that an ICC has to be created in that organization. But if there's anything which is shared informally or verbally, then it cannot be considered as a complaint under the Sexual Harassment Act. The complaint has to come in writing. Thank you.
Thanks, Rohan. So, as we can see, there is a lot of flow of questions from our audience, but with the interest of time, we'll take up the last question of the day today, which is,
Sure.
does Sanam S4 helps the companies on providing guidance on the matter related to sexual harassment? Rohan, over
Sure.
to
Thank you
you.
for that question. Absolutely. Thank you, Tanu. Thank you for the question. Yes. So Sanam S4, as I introduced at the beginning of the presentation, is a consulting organization that helps companies who are moving into India on all the legal requirements of a company to operate in India. Also offers guidance on employee related matters, and one of the things is to create awareness about different employment laws which are applicable to the company. So we do help and we do advise many organizations operating in India today on the matters pertaining to sexual harassment of women and the Workplace Act. Very often we conduct orientation programs at the organizations where in front of the employees directly, and we cover all the details and the nitty-gritties of this act. We make that program very interactive and participative. A lot of questions are asked to us. We also in detail talk about various case studies and references which are pertaining to this act, which are happening in the society or the society has dealt in the past. So the idea is just to not create awareness of the policies and the provisions of the act, but also to create a basic understanding within the employees about what this act means to them, what are their responsibilities, and also then we create optimum understanding within the internal complaints committee and within the employer's management team about how should they look at it. Many times we see that the companies don't have an internal complaint committee, so we then make sure that we create an internal complaints committee with our experience and guidance is offered to them, and we take a thorough orientation about the ICC's provisions so that the members of the ICC are absolutely clear about their duties, about the act, and about what mechanism they should follow and how should they really resolve the case which comes in front of them. So we do offer this to many of the organizations across cities like Delhi, Mumbai, Gurgaon, Bangalore, Chennai, and Hyderabad. Thank you.
Thanks, Rohan, for sharing your views. So, I understand that our audience might have certain questions related to this webinar. So, with the interest of time, we will not be able to take up all the questions, but I would request our attendees to mark the questions to our speaker. So, you can see the contact details of Rohan Muktali and myself on your screen. So, you can post your questions respective email IDs, and we would be happy to answer your questions on offline. So thank you so much for attending this webinar today and taking out your time. We appreciate your time given to us, and I also hope that you find this webinar quite relevant and useful to your end. So thanks our audience, and thank you, Rohan, for taking out your time.
Yeah, thank you so much to all the attendees.
So
Uh, you can always approach us if you have even any other employment related questions, or if you need any consulting on any of the HR matters like employee grievances, employee relations, compliance, and any other complexities of the business which are pertaining to people. Our contact details are in front of you. Do write to us, and we would be happy to take up those questions which have not been addressed today. So thank you again. Have a wonderful day ahead. Thanks for your time. We appreciate it.
thanks everyone.